But at least now it can't get much worse.
But it did get worse.
How's it going, chat? It's a balldoverse collapse side character episode. Oh my goodness, what is going on? How could a fun little stream, Joe celebrating his 100K subscriber. Congratulations to Joe. Congratulations to him. Look at this. You got Sean and Nick in the same clip. This is crazy talk. There's a bit of a Nick update, by the way. But this show is mostly going to be the side character episode about Joe. Now, I'm going to come out straight away and say that I actually like Joe. Not that I watch his content recently, because I don't really watch any content recently because I've been so busy. But, you know, I've chatted to him once or twice. He's pretty nice to me. I've been on his show once, I believe. Very briefly with Max Mura. We jumped on there about a year ago, I think it was. A long time ago. But it looks like he screwed the pooch on this one. I would like to think, I would like to go into this believing that it was a mistake made out of ignorance rather than malice, but we'll have to, you'll have to be your own judge on this one, I suppose, as he has been regretfully, oh, the wrong one. Regretfully, the judge in this case has decided that Joe is ordered to pay $117,636.24. It's a bad, bad time. Not even that. Joe is now part of precedent in the New York district. They're going to be looking at his case for violations of the Fair Debt Collection Practices Act. It's a bad one. That's not a good look. It's not a good look. But let's take a step back for a second and let's see how we got here, because I've been trying to trace the origin of this story, and it seems like it came from this clip on Alyssa channel, on Alyssa Clips' channel, which is very funny. And we'll take a brief moment to check this out. So what happened? GoodLawgic, he's a lawyer. He covers mostly Trump stuff these days, I think. It's like almost like 100% Trump stuff, election stuff. But he kind of got his come up starting off with Rekieta, obviously, and he's just passed 100,000 subscribers. I thought that this was like, I thought that he was being underserved in the algorithm. Honestly, like it seems like he was stuck at 90,000 for a very long time. But anyway, he had his celebration stream. He had a celebration stream. Invites all his friends on. Somehow, either by design or accident, he has Sean on at the exact same moment that Rekieta comes on. Well, I mean, Sean's on, and then he adds Rekieta. So we'll take a look at what happened. There's a few little funny things here. Sean Bros can't stop winning. So let's see what happens.
So I have someone backstage here. Our good friend Nick Rekieta. How are you?
Hey. So obviously Sean is like the kind of the deepest lore on this clip. Sean has been covering Nick's case quite extensively, like I have myself. So I wonder if Joe is unaware of this, or he was just thinking about those super chats. I mean, he is now $100,000 in the hole, and he would have known about being $100,000 in the hole, because I think this judgment came out in September, and this stream happened a couple of days ago. But so Nick comes on, he's in the kitchen or whatever, so you know it's a good time. Let's see what happens. You can see Sean is always like, here we go again. And the same shit, different day. Just like that when he was on with Anna.
Hey guys.
What's up, guys? I hope I'm coming through okay. I have someone else's headphones in. Everything's a disaster over here.
Sounds like a potato.
It's an evergreen comment for Nick, but at the Rekieta residence.
It sounds, but like
oh, great, perfect. I just hopefully won't sound like I have a gun in my mouth. Anyway, what's up, man? How you doing?
No matter how the stream goes, that's how people are going to say you sound. So
might as well.
I was in the middle of, I was going through like a diet phase, and
some people should try it.
Oh, there you go. There's the first little dig at Sean from Rekieta. You can see them there just seething, and like if you actually look at his eyes, he's absolutely seething in that look. And his first little dig at Sean. Maybe have a diet. Of course, everybody knows that Sean is a little bit rotund.
You don't get to steal the Jew defense. You don't.
You get to borrow it. No, Joe's going to just start mailing out pages to everybody. That's going to be his 5K gift for local.
Sean with a nice little comeback. I think it's a total Sean victory on this one.
You have to admit that operation took a lot of balls. Shout out to Sean.
No, I'm going to say like the pager thing, that is BS. Like just like intercepting pages and filling them full of explosives, that sounds like bullshit to me. Like the potential for collateral damage is just disgusting on that.
On the beard for apologizing, making things right with Nick. Okay.
Don't ever expect it, ladies and gentlemen. Don't ever expect it.
Oh, we can be
wish
frank
you
about
and
it.
your family.
It's
Wish
pretty
you and your
awkward, pretty
family
awkward.
well, Nick.
Thank you.
You all are.
So the clip cut, that's kind of like the gist of the clip. It goes on like this. There's a bit of awkward interactions. There's a bit of a post thing where Sean is chatting with Joe, and Sean's like, you know, this could, like, someone asks about the most awkward moment on stream, and then Sean will say like, you know, I could probably have a good contender for that. So that was a very fun. I think most people that are following this sort of saw this clip and was like, had a bit of a chuckle, bit of a giggle. But if you go down, enhance the comment section, something weird happens. Two parties in a conflict and the Joe benefited financially. Say it ain't so. And it's like, so people having a bit of giggles here. There's about 187 upvotes on this one. But then there's this weird comment. I think this is the first person. Oops. I can't really. Oh, hold on a second. We'll open up the crime computer. How about that? We'll open up the crime computer for a second so you guys can read this comment just like I can. There we go. Enhance. There we go. Enhance and open it up in the crime lab, and now we can actually zoom in. So this person, Paul, I guess 1966, posted, he needs the money. He owes 177,000. Well, actually, I think was it not 177,000? I think it's 117,000, but close enough. Close enough. It's only 60,000 off. Per final judgment signed last week by Judge Roman on the 24th of September in American units, which is very frustrating. He was sued as a lawyer and a debt collector. Ooh. Now, that's now it's bad enough to be a lawyer, but to be a debt collector as well, that is a bit oof. That is a bit oof for me. Debt collectors obviously not very popular, but hopefully he was a good boy, right? I don't know. You'll have to see for yourself as we go through this. So someone says, Trevor, I guess, he's got a bear. Angry bear is a profile picture. He says, wait, Joe got sued? Yes. Levy v. Law Offices of J. Henry Nierman. Now, this is one thing I want to point out. I've never heard Joe described as J. Henry Nierman, and I thought there might be a lot of debt collectors with the name Nierman from New York. So I decided to try and do a bit of due diligence on this story, and I went through, and as far as I can tell, this is the same Joe. Joe Henry Nierman is Joe GoodLawgic. If by some chance it's a massive coincidence that this guy is also a debt collector from New York, and I looked at the registrations of the businesses and cross-reference them with what I know about everything, and it seems like it's the same guy. It seems like it's Joe, but on the very small chance it isn't, then I apologize. But going forward with this information, we're going to assume that J. Henry Nierman is both Joe Logic, GoodLawgic, Joe Nierman, as you know. And if you're an early watcher of Rekieta, you may remember that Joe was kind of trying to hide his name for a while on YouTube. Anyway, he says, and after last week and 8 years in court and hiring 2 lawyers for himself, Joe still lost. Now, it seems like he tried to defend himself as well, but if you go into the court listener by Free Law, you can actually see this. This was last updated today, actually. Wow, look at that. It's hot off the presses. You can look at the parties and attorneys, and you can see all of the documents here. We're going to go through not all of them, because this one's a bit of a dry story, but there are a few nuggets in here. Let me tell you. If we go to the parties and attorneys, we can see that J. Henry Nierman was represented by Joseph Nierman, and also the law offices of J. Henry Nierman, represented by Barry C. Schnaps, and then also Recovery of Judgment, LLC, represented by the same Barry. Now, I believe that both the law offices of J. Henry Nierman and Recovery of Judgment are Joe's companies, or he may have been a co-founder of Recovery of Judgment. This is referred to as ROJ in these documents. And then also the defendant is Shaw Levy, represented by Daniel Adam, D.A. Schellinger, and a few other lawyers. There you go. So this has been going on for 8 years. That's kind of important to this story, and it's going to be important to I guess, your judgment of Joe at the end of it. And yep, that's all we need from there. Right. Now, this came up. We'll start here. 50 years McClinchy. I believe this is just some sort of legal office blog news site or whatever. It says New York District Court legal fees are sufficient for standing in the FDCPA claims, and that is the Fair Debt Collection Practices Act. So let's see. On May 20th, 2024, the United States District Court for the Southern District of New York issued a decision holding that the legal fees resulting from violations of the Fair Debt Collection Practices Act constitute a cognizable monetary harm for the purposes of establishing constitutional standing. Case overview. In Levy, plaintiff brought claims for violation. So this is the accused is Joe, who is the violator of these claims. And you can actually look at this. If you go to the issued decision, it brings up the court document, the opinion and order that we'll get to very briefly. Actually, I think we'll do the quick Nick update maybe, because it's very, very short. We'll use that to kind of cut these sections up a little bit. Wait. Let's see. Brought violations of the, we'll just call it the Debt Collection Act, shall we? Against a debt collector law firm, its principal and a company through which the attorney practiced judgment enforcement. Defendant sent plaintiff, who resided in Florida, a letter and purported post-judgment subpoena, Deuces Tecum, basically requesting information, in relation to a money judgment awarded in New York City civil court case. Now, I actually don't know much about the civil court case. It is mentioned in these documents, but I was unable to find out the what started the civil case, and it was very difficult for me to find. So, unfortunately, we don't know what the actual, I guess, instigating lawsuit was, or civil law case. The subpoena commanded plaintiff to appear at a deposition in New York City on a federal holiday. Say it ain't so, Joe. Now, anyone want to guess in chat? What federal holiday do you think that Joe was requiring these people to show up at? It's a little bit of a spoiler. It's a bit of a spoiler to go into the document straight away, because we want to see things kind of in order, right? But this seems like a big blunder. And like I said, I want to believe. Good Friday. Hey, come on now. Hanukkah, Christmas, Kwanzaa. Yeah, there's some good guesses in there. Good guess. I believe it's in this document. If we scroll down to the exhibit, this is the subpoena Deuces Tecum that Joe allegedly sent to this person. Let's see. We'll read that. We'll read this first. We'll see if we can pick up anything. So you got this big final notice over it. Very professional. Let's see. The peoples of New York City to Shaw Levy. Greetings. Wherein, in an action of the civil court of the city of New York, County of New York, between Matt Morrison versus as plaintiff and Shaw Levy as defendant. So I couldn't find Morrison versus Levy. I tried looking for it, but I couldn't find it. So if you know any more about this case, I'd be interested to know. But basically, it was like something in the range of like $15,000 worth of damages for some reason. Defendants, let's see, who are all the same parties named in the said action. The judgment was entered on, and now this is American, so it is May 11th, 2010. So this actually goes back quite a while. Of course, I believe this was launched. This was sent in, I think, 2016. So this has been going on for like 7 years. In favor of the plaintiff, judgment creditor against Shaw Levy, defendant, judgment debtor, residing at his residence in Miami, in the sum total of $8,700, of which the sum of $13,990 remains paid undue. Sorry, I have to say it. $8,000. What do you need $13,000 for? No, I guess it's just the way it was. The original sum is probably $8,700, and then this is the sum with interest and things like that. But it's kind of funny how that works, right? All right. Now, therefore, pursuant to the sections blah 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 of debt collection, we command you to appear and attend before judgment. A recovery of judgment, that's the company, in New York on December 26th, 10 a.m. Literally stealing Christmas. Well, Boxing Day. Say it ain't so, Joe. Joe, no. Don't steal Christmas from this dude. What are you doing? Oh, my goodness. More like Grinch logic. No. Come on, December 26th. He has to have known. Like, he has to have known. Joe, what? He can't turn off lights on Saturday, but he expects you to come to court on December 26th? Come on now. So he's requested on December 26th, which is a federal holiday, apparently in America. It is in New Zealand as well. But I have to kind of gleam everything through the lens of what I know, right? And at any recessed or adjourned dated for the talking of disposition under oath upon oral or written questions. And then he also, we'll get back into this when we go through this in order, but he basically requests, he wants everything. He wants everything. He wants 5 years of banker statements, financial records, all deeds, certificates, registrations, statements of stock. He wants it all. He wants it all, and he wants it on the day after Christmas. I believe he also says any jewelry, art, antiques, precious objects, gold, and precious metals, total market value owned by the debtor. And I believe it also says you cannot sell anything in here. But again, we'll go through this with a bit more of a fine comb as we get to it. And there's a restraining notice, take notice pursuant to section blah blah blah, which I believe, forbidden to make any sale, assignment, transfer, interference of any properties in which you have interest. And it goes on like that. And we'll get back to this, like I said. But there you go. And it's signed by Joseph Nierman, Esquire, attorney for judgment creditor, recovery of judgment. Now, like I said, I do like Joe, and he has been nice to me in the past. So I can only hope that this was sent in ignorance rather than malice. But it's not looking good so far. Requesting to show up at 10 a.m. on December 26th. And I believe, what was the date this was sent? I think this was sent like within 10 days of that date, actually. The exhibit B. Is there a postmark on this? I think that says the 13th, but I'm not sure. We'll have to go back and check. I believe it will actually come up in the court documents. But we'll have to see. All right. So I guess... Oh yeah, we'll with that the preamble of the stream finished, I will remind you to like the stream. It is very helpful if you could do that. It's Jova. It might be. You remember to vote in the poll. Was it a mistake? Is Joe a good boy? Was he a debt collecting fraudster, or is it just a big oof of $117,000 he now owes? And you can also see the results and like the stream. I wonder if Joe has started a GoFundMe. This will become more relevant as we go on, but I'll save this one for later. And let's see. If Joe has to pay $100K in legal bills, he's probably out a similar amount for his own attorney. Well, he did represent himself, so I'm not sure if he's going to collect on himself. I mean, maybe that could be like a special infinite money glitch. Might help him get out of debt. Who can say? All right. Brief Rekieta update. I remember, I think I said last time, it was going to be maybe December, January, before we got any more Nick news. So No Nick November was almost set to happen, but No Nick November has been cancelled because we have a notice of hearing in person for Nick Rekieta, November 26th at 2:15 p.m. What this means is that Nick's got to show up. And basically, he's got to say, hey, look, I'm either innocent or, well, I mean, he can plead guilty here, or he can, hold on, where's my notes on this one, actually? Let me just bring this up so I get this correct. Let me see. Yeah, so he has to show up on the 26th, and he has to enter either his guilty or not guilty plea. So this will be when everything goes down, basically. If you're like looking forward to updates in this case, he can take a plea. He can plead not guilty, government conspiracy, and then the body cam gets introduced into evidence, I suppose, when the trial date comes up, although that might be a while away. Like, it might not just be the next day. It's not like December 26th body cam footage watch party. That's not going to happen. I would assume that he accepts a plea before this happens, but we'll have to wait and see. But this is going to be the big boom date. Now, I actually do have some travel plans for November around this date, perhaps even on November 26th itself, but we'll try and cover this in timely fashion. And Eva Blink, member for 25 months, says 25 months of membership will have a BP tribute. I hope that's not the tribute as I understand it, but anyway. There is also a Barnes walking update, but we'll leave that to the end, I think. That'll be like the ending cope of the stream. So let's get into the complaint, shall we? This is the complaint against the law offices of J. Henry Nierman, Joe Nierman, who we assume is, it seems like it is the same one. Introduction. This is an action for money damages and declaratory judgment brought by an individual consumer for defendants' violations of the Fair Debt Collection Practices Act. And then they have the statute. And the New York General Business Law. The action relates to defendants' illegal, deceptive, and abusive attempts to collect allegedly unpaid judgment via a flagrantly unlawful and improper subpoena. Not looking good so far. Let me see if I can get that right. That's about it. Looks all right, right? No, there we go. That's the perfect one. Moreover, the underlying judgment that defendants were purportedly attempting to enforce appears not to exist. Let's see the jurisdiction and venue. So let me see. Jurisdiction is conferred by 15 U.S.C. Declaratory relief is available pursuant to, and there's a. I'll try and cut through this one because, like I said, it's a bit dry. Venue in the district appears proper because defendants both reside in district acts and the transactions that give rise to this action occurred in substantial part. Let's see the part. We have the plaintiff. So Shaw Levy is bringing this against Joe. And he is a consumer. He loves to consume. He's probably watching the Rings of Power right now. He loves to consume. I need to get tongue lessons. I'm a little bit tongue-tied today. I'm actually very sleepy, but I'll do my best. The defendant is the law offices of J. Henry Nierman, which is referred to as LOHN. It is a third-party debt collector whose principal business purpose is the collection of debts. Now, Joe has talked about being a debt collector in the past, which is something you probably wouldn't want to ever admit to. Right up there with being a lawyer. And I say that as I have some lawyer friends in the chat. But yeah, no one really typically likes lawyers very much outside of LawTube. And nobody likes debt collectors. Nobody likes a debt collector. So the law offices of Joe, we'll try, every time we see Lon here, we'll just refer to it as Joe. Joe regularly attempts to collect debts alleged to be due to another and is a debt collector as defined by the, I guess this is the Fair Debt Collecting Act that he has violated or alleged to have violated. He is engaged in the business of debt collecting in New York and maintains its principal place of business, and it's got his thing. The defendant is J. Henry Nierman, a third-party debt collector. So it's kind of confusing because he's both the company and the lawyer himself. But yes, so he's mentioned multiple times. That's the interesting thing about law documents is that they're very annoying to read. Nierman regularly attempts to collect debts alleged to be due and is a debt collector. Nierman is engaged in the businesses of collecting debts in New York and maintains his principal place of business. I read that already. Defendant, Recovery of Judgment, LLC. Recovery of Judgment is a foreign limited liability company, according to its own website, and a third-party debt collector focused on judgment recovery. I believe this is either Joe's company as well, or he co-founded it when I was looking up this prior to the stream. Megals with a 20 Australian says, oy vey. That's going to be probably get a lot of use in this stream, I would imagine. Recovery of Judgment is engaged in the business debt collection. As stated above, all three defendants share the same business address. There you go. So Joe, and those two businesses both have the same address. And that's when I looked it up. I found that as well. All set forth herein and in the attached exhibits, Nierman and his companies sent to customers dunning letters, so demanding letters, that list the same address, phone numbers, and fax numbers as the address, phone, and fax recovery of judgment as listed on the website. As set herein and the attached exhibits, Nierman and his companies sent out dunning letters that list the website, Recovery of Judgment, and list Nierman and the company as support@recoveryofjudgment.com. Upon information and belief, the defendants are united in interest and in essence operating one unified debt collecting operation controlled by Nierman. He is the mastermind debt collector. Facts. Okay, this is where things start to get a bit rough. There's actually like, I think it's this document, the report and recommendations. This one is a bit of a hard read, honestly. Like I went through it and it's like, it's a bit of a sob story, but I think it's kind of important for the for understanding what is actually the effect of this entire event, right? So let's have a look at the facts. Plaintiff repeats and realleges and incorporates by reference of the foregoing paragraphs by letter dated December 10th, 2016. So actually, I want to open up a second copy of this so we can refer to the evidence as we go through it, because there we had the letter. So Joe sent the man a letter on December 10th, and he required them to come to court with everything 16 days later on Christmas Day. There we go. There we go. So there we go. There's the letter. Joe will file an appeal. He's been appealing it for 7 years. I don't think the appeal is going to work, buddy. I don't. 2017. This seems to be the final judgment. He's been. Honestly, I feel bad for this guy, because even if Joe did make this mistake in ignorance rather than malice, he put this guy through $100,000 worth of legal fees and 7 years worth of anguish. That is the reality from my preview of this case. And Bob with $2 Australian, a lot of Aussies in the chat today, says, knowing Joe, he will round. Come on now. 177,000 up to 6 bazillion. There you go. There you go. All right. By letter dated December 10th, postmarked December 13th. Oh, I was right. I was right when I said December 13th. Look at that. I read the blurry image. Where is it? There it is. I thought that said 13. I thought that said 13. And sent by regular mail, defendants sent to Mr. Levy the letter and purported post-judgment subpoena Deuces Tecum attached herein as Exhibit A. The subpoena purports to be issued in regulation to a judgment in Matt Morris versus Shaw Levy taken in the New York Civil Court, County of New York, with a purported index number of, and then you have the case number. The subpoena is addressed to Mr. Levy in Florida and commands Mr. Levy to appear and attend before recovery of judgment in New York on December 26 at 10 a.m. Boxing Day. Boxing Day. Grinch logic. Oh my goodness. You're still recovering? You're still recovering from you're still recovering from your Christmas night out, and you've got to be in court at 10 a.m. Now, this is a court holiday, so that, of course, was never going to happen. I guess it just slipped his mind that it was Christmas. I wonder how that could happen. Actually, kind of funny thing about holidays is Nick's hearing is the day before Thanksgiving. Is that how it works in America? Is Thanksgiving November 27th for Americans? Like the 4th Thursday, right? 1, 2, 3. Yeah, so Nick has to appear in court and plead guilty or not guilty just before going to Thanksgiving. So that'll be a fun one. That'll be a fun Thanksgiving, won't it? Also, I forgot to mention, but another slight balldoverse update is that Nick and his wife have changed their registered address to their parents' address, which is very strange because now I guess only April is the only one registered to be living in the Baldo bunker. Very, very weird. Very weird. Funny and weird. So let's see. They have to show up on Boxing Day, the day after Christmas, which was a federal holiday. Federal holiday. The subpoena further commands Mr. Levy to bring with him comprehensive financial documentation, including statements of bank accounts debtor has maintained in the past 5 years, all federal and state tax returns for the past 5 years, etc. The subpoena also contains a restraining order notice stating that Mr. Levy is forbidden to make or suffer any sale, assignment, transfer, or interference with any property in which he has an interest, except upon direction of a sheriff or pursuant to an order of the court until the aforesaid judge is satisfied or vacated. The restraining notice further states that disobedience of this restraining notice is punishable as a contempt of court. The subpoena states final notice in large letters across each page. And if we look at the evidence here, the letter that's sent, every single page has this final notice. And this appears to be the first letter that this person ever received, which is a bit odd in it. The accompanying letter from law offices of Joe Nierman and signed by Mr. Nierman, but listing the address, phone number, and website and email shared of defendant recovery of judgment, warns that failure to comply with a properly issued subpoena entitles the creditor to move the court to impose sanctions on the debt and request additional fees. Fines and or imprisonment, and that is in Exhibit B. The subpoena and accompanying letter are flagrantly unlawful and in gross violations of New York's law and the Fair Debt Collection Agency Act, I believe that is. The subpoena and accompanying letter were sent to Mr. Levy in Florida, wherein the purported default judgment in question is listed as being having taken in New York. Such out-of-state post-judgment subpoenas are void under New York law, which has no provision for service of a subpoena under a judgment debtor without a state. And then they have the Summons versus Helsky. Let's say, which in regards to voiding a post-judgment subpoena and holding that while a summons may be served outside of the state, there is no such provision for a subpoena. Service of the subpoena upon judgment debtor without the state is void. Even were this not so, the subpoena is nullity because it was required to be served in the same manner as summons, whereas defendant's letter and subpoena were sent via regular mail. Regular mail would not be valid service with regard to a summons and is therefore not valid service in regards to the subpoena. The subpoena is also improper because it is required to set forth a disposition date that falls during regular business hours, whereas the subpoena calls for a disposition to occur on December 26, which was a court and national holiday and therefore does not qualify. Oy vey. December 26 is a holiday? Imagine that. Moreover, the subpoena was not timely as it was mailed at earliest on December 13th and did not arrive until less than 10 days before the supposed disposition date. The subpoena also lacks the statutorily required language set forth in Act 22 of the New York law. Because the subpoena was unlawful, the cover letter, which was also labeled final notice and suggested that Mr. Levy could face fines and or imprisonment should he fail to reply, was also unlawful. Moreover, the underlying action does not appear to exist. Oof, that's a bad one. Specifically, prior to filing this litigation, the undersigned sent a letter to Nierman stating, inter alia, I believe that's amongst other things, that Mr. Levy did not recognize the underlying action. Subsequently, in conversations on December 27th, Nierman indicated that he would send counsel for plaintiff the underlying court file. Counsel for plaintiff followed up on this request on January 12th via email. Nierman did not respond. You see, this is the really kind of like sad thing that happens in this one, is I think that this was generally a mistake. I think that Joe had some bad information. This is at least what I want to believe. What we want to believe and what may actually exist can sometimes differ. But I think what happened is that Joe made an assumption. He made like what Ty Beard would describe as a bad notary mistake. And then he's like, you know what? I'll check up on this and I'll get back to you. But then he just never responds. So this guy's like in limbo, getting a letter just before Christmas. And he's saying, wait, what the fuck? What is this? What the fuck is going on? And then Joe just doesn't respond. Now, I've been through like 5 of these documents and I can't actually find Joe's argument at all. It seems like he just keeps appealing to get rid of it. But he doesn't actually stay like, well, I made a mistake. It seems like he just put this guy through 7 years worth of anguish because he made a mistake. At least that's my read of the situation. Since that time, after conducting initial research that failed to identify any underlying action with the caption listed in the letter or subpoena, Matt Morrison versus Levy Shaw in New York Civil, or a case with a similar name listed by the index number provided in the letter and subpoena, my office conferred with New York Civil and Supreme Court clerk officers. The clerks were likewise unable to identify any such action in their databases. So not even that I was unable to find this. It seems like this just doesn't exist. So is this actually just like debt collection fraud? Because I don't know. I wonder, because when you look at the website for this, I think if you go to the evidence, right? Because there's a lot of unanswered questions for this one. I think this is kind of just coming to light. But if you look at Joe's website, recovery of judgment, no recovery, no fee. I wonder if someone sent in a bogus debt collection against this dude. And I guess maybe Joe did no due diligence and just tried to start collecting immediately. I don't know. If you have any ideas, let me know. I like to think that this was a mistaken situation. But the fact that he's trying to get this guy to come in on Christmas and he keeps appealing this for 7 years, causing $100,000 worth of legal fees, instead of just saying, whoops, we made an oopsie, it doesn't give me a lot of faith in it. It makes it a bit hard to swallow this one. The clerks were likewise unable to identify any such action in the databases. Based upon this inquiry, it appears that plaintiff hereby alleges that the underlying judgment does not exist. In the alternative, the underlying judgment has been materially misstated in the collection communications received from the defendant. There's, let's see. First cause of action, violations of the Fair Debt Collection Practices Act. Plaintiff repeats and realleges and incorporates by reference the foregoing paragraphs. By undertaking the above reference collection activities, defendant violated this statute, and then they have the statute. Specifically, and without limitation, defendants violated the, what is this again? The Fair Debt Collection Practices Act through a host of false, deceptive, and unfair conduct in violation of 1692E and 1692F, including, inter alia, falsely representing the character among a legal status of the purported debt, falsely representing that a judgment had been obtained against Mr. Levy in an action in New York Civil Court, captioned Matt Morris versus Shaw Levy, with the index number of, then it goes into the number, threatening to take action against Mr. Levy that could not be taken, and that were never intended to be taken, the taking of his disposition in New York, moving the court to impose sanctions on Mr. Levy and or request additional fines and or imprisonment of Mr. Levy in the event he did not appear or otherwise comply with the unlawfully issued subpoena, making false representations and deceptive means to collect or attempt to collect any debt or obtain information concerning Mr. Levy, falsely representing that documents are legal process, and attempting to collect amounts not authorized by any agreement creating debt or permitted by law. As a result of the defendant's violations, plaintiff has suffered actual damages, including attorney's fees and costs, aggravation, nervousness, emotional distress, fear, loss of concentration. Sorry, I think the games are starting to escape from my brain. Loss of concentration, indignation and pain and suffering, inter alia, in connection with the false prospect of being held in contempt, fined, and or imprisoned per defendant's letter and subpoena. As a result of these violations, plaintiff is entitled to statutory damages of up to 1,000 actual damages and attorney fees and costs. Second cause of action. Plaintiff repeats and realleges and incorporates by reference the following paragraphs. They say that every time there's a new thing. Each of the deceptive acts and practices set forth above constitute violations of the NGBL, independent of whether these acts and practices constitute violations of any other law. These deceptive acts and practices were committed in conduct of business, trade, commerce, or the furnishing of a service in this state. Specifically, the deceptive acts and practices occurred in the course of defendant's attempts to collect a purported consumer debt that defendant alleges has been reduced to a New York state court judgment. And these collection agents, the drafting and sending of various deceptive and misleading documents referenced above, took place largely in New York. Defendants' deceptive acts and practices were consumer-orientated. Defendants' conduct was not unique, one-time occurrence without possibility of replication or reoccurrence, and without implication for the broader consuming public, but rather involved misleading, boilerplate documents sent by a high-volume debt collector to a consumer. Now, this is kind of the people that are really going after Joe hard on this one. And I received some DMs about this. I'm sure a lot of other people received DMs about this. I think I'm the first person to talk about it because I kind of had a free day today after I got back home. Also, like, I actually don't begrudge if anyone doesn't talk about a certain case. It's like some people are like, you have to talk about this because it's no, you don't have. You don't have to talk about your friends' court cases. I don't think there's anything wrong with that. If Sean, like I consider Sean my friend, potentially Sean my friend. If he went off and did a bunch of tax fraud or something, I wouldn't talk about it in public because he's my friend. So if you're a friend of Joe, I don't see any fault in not reporting it. And people are like, it's hypocrisy. No, I don't agree with that at all. But anyway, to go back, the people that are really going after Joe on this one, they're saying, well, what about if this is one that he kind of slipped through the cracks? How many of these did he send out to people that just never reported it or never responded to them? I mean, that's a question, right? Kitty says, happy Josh Tober, spoopy boys and goyles. Thank you. Yes, it is Josh Tober now. It's the second. And Excumer says, Joeing, big surprise. Yes, he's a Joe. He's definitely Joe. Joe Logic. Can legal mindset cover my case when I get arrested in Japan? No, because he's not barred in Japan. Japanese legal system is actually a nightmare. Trust me about that. It's really crazy. For example, in Japan, you can be sued for banging someone else's wife when you don't know that they're married. That is a very real court a thing that the court can do. You can literally be the home wrecker sued as a home wrecker. I know this because at one point in my past I was dating a female lawyer, which I know was a big mistake, right? All the lawyers I've talked to said that's a big fucking mistake. But anyway, she was a family lawyer, and she was telling me about a case where she was hired to sue a woman that her husband was cheating on her with, right? And this was just like some 25-year-old chick that had no idea he was married, but he was married, and he did cheat on his wife. And then the wife found out, and she couldn't sue the husband, so she's like, "Well, I'll just sue this recent college graduate for everything that she's fucking got." Japanese, very, very interesting laws over here. Defamation is another fun one. You can be sued for defamation even if the statement is true. Truth is not an absolute defense in Japanese defamation. That's why you have to be very careful if you want to say anything about anyone in Japan. Even perhaps leaving like a bad review on a restaurant could put you in a bit of hot water, essentially. Well, this food was undercooked. Yes, it was, but you still caused us damage, so now we're suing you. It can actually happen in Japan. But no, legal mindset's not barred in Japan, so he wouldn't be able to defend me. So I'll have to make some more lawyer friends somehow. What is this? Are you seen as guilty in Japan until you're proven? Well, thing is, Japan has like a 99% conviction rate, because what they do is when they arrest you for like a crime like drug possession or violent crime, they put you in a box, basically a small room, and they can keep you there for 25 days. And they can just put you in solitary confinement for 25 days, or something close. It's like 25 to 30 days. And then people just crack and just admit to be whatever the guilt they're being arrested for. It's very unethical. Actually, on my to watch video list, I've got a video I want to go over with Max and perhaps some lawyer bros, where we look at the actual horrors that is Japan's death row. There was recently a guy that was on death row for 50 years. And he was completely innocent, and he's just been freed. But like when you're on death row in Japan, they don't even tell you what day you're going to die. So you're just like waiting in mystery, like, is today the day? And they do that specifically because they like torturing you in jail. Japanese jails, they just literally torture you psychologically and physically. It's not a good place to be. But you can go visit the jail for curry day, which is nice. You can bring the whole family, and the prisoners will make curry, and you get to eat it, and then you get to go home, and then they get to suffer. So there you go. There you go. Anyway, sorry, getting back to this. We got sidetracked there for a second. Harsh but fair. I don't know about that. Let me see. So defendants' deceptive acts and practices were consumer-oriented. Defendants' conduct was not unique. One-time occurrence. Oh, yeah, we did read that one because we were just talking about that, actually. Defendants willfully and knowingly engaged in deceptive tactics set forth herein in bad faith. Oh, my goodness. And on information and belief, do so on a regular and reoccurring basis. This is a pretty serious allegation. Defendant's statements and conduct set forth herein in the attached exhibits were materially misleading. Now, it's worth remembering that this is the complaint issued against Joe. So everything that happens in this is not actually what happened. This is the beginning of the lawsuit, and it's requesting I believe it was requesting a jury trial demanded complaint. Yeah. So this is what Levy is accusing Joe of. It's important to note that part. But like, it was important that I should have saved my place, because now I have no idea where we were. Where were we? No, we went through the parties. We went down to, I think we're pretty much through. I was right here. The first cause of action, right? I remember being around 50. It was around there. I was right about, yeah, the Nierman did not respond. There's just these page numbers. I should have just remembered those. There we go. All right, here we go. I found it. Defendant's statements and conduct set herein and in the attached exhibits were materially misleading. As a result of these violations, plaintiff suffered, inter alia, actual damages set forth in paragraph 52. For these reasons, plaintiff is entitled to actual damages, declaratory judgment, an injunction of the deceptive practices set forth herein, including inter alia, an injunction against defendants sending out subpoenas of the type described herein to consumers living outside of New York, an injunction against defendants sending out subpoenas to any consumer via regular mail, and an injunction against sending out subpoenas that fail to accurately and completely set forth the caption, the index number, the identity of the judgment creditor, etc. 3 times actual damages of up to $1,000, punitive damages, costs, and reasonable attorney fees. Wherefore, plaintiff respectively requests the court award a declaratory judgment of defendant's conduct violated, and then they have the Fair Consumer Act and not Consumer Act, but the Fair Debt Collecting Act. Injunctive relief pursuant to New York GBL. Actual damages, statutory damages, cost and reasonable attorney fees, and such other and further relief as law or equity may provide. Demand for a jury trial. Pursuant to Federal Rule of Civil Procedures 38, plaintiff hereby demands a trial by jury as to all issues so trialable. Respectfully submitted by Daniel Adam Schellinger, who is the plaintiff's attorney. And now we get to the exhibits. So let's see what Joe sent out. Let's see what he sent out. And all right, here we go. So he sent the subpoena Deuces Tecker. So that's like a demand. Bring it all to the to Shaw Levy. And we did kind of read this at the beginning, but we're going to go through it again. Greetings, wherein in an action in the civil court of the city of New York between Matt Morris and plaintiff Shaw Levy. Now we could not find this court case. There's no number for it, and apparently it just doesn't exist. So it's just completely made up, it seems like. As defendants who are all the parties named in the said action, a judgment was entered on May 11th, silly Americans, in favor of plaintiff judgment, creditor against Shaw Levy, defendant judgment, debtor residing at Minami, that's south in Japanese, Miami Beach, Florida, for the sum total of $8,700, of which the sum $13,990.08 remains unpaid and due. And now, therefore, pursuant to sections 5223 and sections 5224, we command you to appear and attend before recovery of judgment, that's Joe's company, in New York on December 26, 10 a.m., and any other recessed or adjourned date for the talking of deposition under oath, oral or written matters, oral or written questions on all matters relevant to satisfaction of the judgment. We hereby command you to produce the examination at the time and place indicated above, certain books, papers, or records to wit. So this was sent out on the 13th, and within 13 days, and I'm not sure how many business days that is, but basically, like, I think it's like 10 days, right? That's like something like 10 days. They've got to get all of this shit together and then get their ass to New York on Boxing Day, not Christmas Day, but Boxing Day, the day after Christmas. Statement of bank accounts from the last 5 years. All financial statements for the past 5 years. All federal state tax returns for the past 5 years. Any and all deeds for real property. Certificates, titles, registration, and motor vehicles owned and used by debtor. Statements for stock and broker accounts. Statements for money markets owned by the debtor. Life insurance policies. Oh my goodness, he's going to take this dude out and then collect on the insurance? Holy shit. Any securities, bonds, notes, mortgages owned by or for by the debtor. Any stock, options, commodity contracts. Any broker marketing accounts. Any loans. Any accounts receivable. Any businesses. Any cash. Any vehicles. Any real estate. Any vested interests. Any contingent interest. Any household furnishings. Joe wants a fucking list of his couch. GoodLawgic wants the good intel on what sort of like patio furniture this dude's bought from IKEA. What the fuck? Any household furnishings. Market value of the IKEA table. Joe demands it. He wants everything. He wants it all. Holy shit. Grinch logic. He's going to take everything. Any jewelry, art, antiques, precious objects, gold, and precious metals. Total market value owned by the debtor. Any other assets. All other credit card statements. All statements for utilities, gas. He wants to know how much you're paying for fucking gas in Florida. Now, I assume this is kind of like, this is just something that Joe came up with. I assume this is like what you send out every single time. It's like the boilerplate letter, right? That's what I assume. He probably just downloaded this from the internet, and it probably pre-came with this final notice watermark. That's probably why it's there. He probably just couldn't be bothered to Photoshop it out. I mean, Photoshop wasn't as good as it is in 2010. All credit card statements, all statements for utility, gas, water, heat, cable, any documents related to ongoing proceedings in court, any and all books, papers, and records in your possession. Holy shit, he wants a list of all the books in his house? That'd be easy for me because I only have one book, but that's outrageous. That's outrageous. Take notice that false swearing on such examination or failure to comply with this subpoena is punishable as contempt of court. Restraining notice pursuant to section 5222B of the Civil Practice Law and Rules, which set forth in full herein, you are hereby forbidden to make any suffer or sale, assignment, transfer, interference of any property in which you have interest, except upon direction of the sheriff. So you can't even sell your shit. Let's see. This is also punishable by contempt of court. Effect of restraint, prohibition of transfer, duration. A judgment debtor or obligator served with a restraining notice is forbidden to make or suffer any sale, assessment, transfer, or interference of any property in which he or she has an interest except upon direction of the sheriff or as pursuant to an order of court until the judgment or an order is satisfied or vacated. A restraining notice served upon a person other than the judgment debtor or obligator is effective only if, at the time of service, he or she owes a debt to a judgment debtor or obligator, or he or she is in possession of a custody of a property in which she or she has any reason to believe the judgment or debtor or obligator has an interest, or if the judgment, creditor, or supported collection unit has stated in notice a specified debt. It goes on like this for quite a while. I'm going to try and skip through a lot of this because it's bad. It's bad. It's bad. It goes on, yep, and is dated December 10th in New York City by Joseph Nierman, Esquire. Exhibit B is the law offices of H. Henry Nierman, which is Joe. And you can see there it has the same email. Let me see. Is this one any different? Enclosed herein, please find a subpoena ducis tecum directing you to appear for a post-judgment disposition on December 26 at 10 a.m. and turn over your financial information. Bend over and let me examine everything. These financial documents include tax returns, bank statements. Yeah, so it's kind of just, I guess this is just like the cover letter, I assume. Then we have the letter, which is important because the postmark showing that it was sent out on the 13th. Exhibit D is Joe's website where it's recovery of judgment. No recovery, no fee. Well, it seems like Joe's having to pay his own fee now. Quite a serious one. So that is the original complaint. We'll go over to the opinion and order. So this is what happened. So this one, the first one we went through, this was, I believe, filed in May 30th, 2017. So 7 years ago, this all started 7 years ago, almost 8 years ago. Whatever. I'm not gonna do anything. But it's been filed. It's now been resolved on September 9th, 2024. That's where we skip forward in time. Megals with another 5 says, "Wild, thank you for covering." Oh, you're welcome. You're welcome. Let's see. Shaw Levy, the plaintiff, brings this action against the law offices of J. Henry Nierman. And we're just going to continue to call these Joe because we assume they're all Joe. Alleging violations of the Fair Debt Collection Practices Act. On February 2024, defendant filed a motion to dismiss plaintiff. So this is basically Joe's been trying to get this dismissed for like the last 7 or 8 years. That's what he's been doing. He's been kicking the can down the road, but the chickens are home to roost finally in, I guess this was on what, September? Yeah, September 24th. Pretty recent. Defendants filed a motion to dismiss plaintiff's claim for lack of standing pursuant to Federal Rule of Civil Procedure. On May 20th, 2024, the court denied defendant's motion to dismiss and referred the matter to Magistrate Judge Judith C. McCarthy. They got him with McCarthy, oh my goodness, for an inquest on emotional damages and attorney fees and costs. Now pending before the court is a report and recommendation, R&R, issued by Judge McCarthy pursuant to the Federal Rules and Civil Procedures, recommending that plaintiff be awarded $8,000 in actual damages. I think it's actually pretty hard to get actual damages, isn't it? Am I wrong in thinking this? Like I've seen a lot of LawTube guys say that arguing the actual damages is pretty hard. But he got $8,000. I think he was originally asking for $1,000. But who can say? He gets $500 in statutory damages, $103 $6,214 in attorney's fees. So he's got to pay the fees. And $5,924 in costs for a total awarded. So this is what Joe has to pay. Joe's got to pay this after 7 years for a total award of $117,639.24. The defendant made no objection to the R&R. The following reasons: the court adopts the R&R, the award, and awards plaintiff $8,000 in actual damages, $500 in statutory damages, and $103,000 in attorney's fees, and $6,000 in costs, for a total of $117,000. Background: the court presumes familiarity with the factual and procedural background of this case. Now, actually, one thing I was looking for is I'm not sure if this was, or maybe it's just not listed just yet, but it seems like this never actually went to a jury trial, because I have not been able to find any response from Joe. I don't expect him to make a public statement about this, but I was unable to find any of his arguments or anything in his defense. He just tries to get it, he just applies to get it dismissed, is denied, applied to get it dismissed, denied, and it goes on like that for years. Now, most court cases do take years as well, but this is 7 years of anguish when it seems like Joe made either I want to believe it was a mistake of ignorance and not malice, but it's getting harder and harder to do that with a lot of these. It seems like he was just sending out these debt collection notices left and right and seeing what sticks, essentially, because that's what a lot of high frequency debt collectors do. Is they'll often purchase debt, pennies on the dollar. They'll send out hundreds of debt collection notices, and then if only 1% gets back, they make their money back. So it seems like that's what Joe was doing, but he was doing this illegally or in violations of the act. And then he got caught, and one guy was like, wait a minute, I don't have any judgments against me. I'm going to hire a lawyer for $3,000. And then 7 years later, he now owes $100,000 in court fees. But fortunately, he wins. So Joe has to pay the guy for everything. Let me see. Joe demands a Frank's hearing. That's not going to happen. I think he's exhausted his appeals. I think it's over. It's Jova, in fact. He's got to pay. I don't see him getting away with this one. You can't keep getting away with it, bros. You can't keep getting away with it. So the parties cross-moved for summary judgment in 2001, and on December 8th, 2022, the court entered judgment for plaintiff in his there's the violation of the Fair Debt Collecting Act. The court also awarded plaintiff $500 in statutory damages pursuant to 15 U.S.C. and referred to the case to Judge McCarthy for an inquest on actual damages and attorney costs and fees. Judge McCarthy held an inquest on June 12th, 2023. See June minute entry. At the end of the hearing, defendants sought leave to file a motion to dismiss the case on standing grounds. Oh, no. Sorry, Joe. Didn't work. The court granted leave, and defendants filed their motion for dismiss on February 19th, 2024. On May 20th, 2024, the court denied defendants' motion and re-referred the case for an inquest on emotional damages, plaintiff $3,000 in legal fees, and the issue of attorney fees and courts. Standards of review. In reviewing a magistrate judge's report and recommendation, a district court may accept, reject, or modify in whole or in part the findings or recommendations made by the magistrate judge. Parties may raise specific written objections to the report and recommendations within 14 days of being served a copy of the report. When a party submits a timely objection, a district court reviews de novo the parts of the report and recommendation to which the party objected. When neither party submits an objection to a report and recommendation or any portion thereof, district court reviews the report and recommendation for clear error. And then you have a bunch of case law. To accept the report and recommendations of magistrate to which no timely objection has been made, a district court need only satisfy itself that there is no clear error on the face of the record. When no timely objection is filed, the court need only satisfy itself that there is no clear error on the face of the record in order to accept the recommendation. Discussion. Here, the review and recommendations was issued on July 3rd, 2024, after requesting an extension. You know, that's funny because I can remember where I was on July 3rd, 2024. Where were you? Where were you, Chad? After requesting an extension, defendant had until July 30th to file objections, but they filed none. Since defendants failed to file any objections, the court reviewed Judge McCarthy's R&R for a clear error and found no clear error. As expressed more fully in the R&R after considering the evidence submitted, both parties' evidence suggested supported Judge McCarthy's decision that plaintiff be awarded $8,000 in actual damages, $5,000 in statutory damages, $103,000 in attorney's fees, and $6,000 in costs for $117,000. Conclusion. For these reasons, the court adopts Judge McCarthy's R&R in its entirety. The court kindly directs the clerk of the court to enter the judgment as follows. Plaintiff is awarded $8,000 in actual damages, $500 in statutory damages, and $103 in attorney's fees. In total, for the $117,000. Clerk of the court is also respectively directed to close the case. Case closed. Nelson S. Roman. That's where Joe is. It's Jova, and he owes almost $120,000 in fees for this one. Is he going to get recovery of judgment to help him in his debt collection of himself? Who can say? That'll be the interesting one. Now, there's one other piece of documentation. Like there's like another 5 documents, but like I said, we're not going to go through all of these. But this one, I think we will have a quick look at. This one is a little bit heartbreaking. It's a little bit sad. Now, of course, it will be, right? So this is the defendant, and basically his plea for why he is deserving of emotional damages. And it's like we don't know the court case. Like I don't think there was a court case at all. It seems like that just came out of nowhere. But let's have a little look at the story, because sometimes you make a clerical error. It happens in every job, right? You make a mistake, but there are real people's lives behind these mistakes. So this is what, alleging to the plaintiff, this is what their life was like when they received this letter from Joe. But let's see, where's the best part of this? You don't want to see the entire thing. Let me see. We might have to go back. I guess we'll just. How long is this? How long is this one? It's 18 pages. We're not going to read the whole thing. Background. I think there was the interesting part was damage inquest. I think that's the part where it kind of gets a bit spicy. Okay. So basically they set forth that he received this debt collection order and what it was inside it. Then he goes into the damage inquest. At the inquest, plaintiff and his wife of 10 years, Tessa, testified in support of plaintiff's request for emotional damages. The defense did not call any witnesses, so Joe did not even challenge this. Mrs. Levy testified first. She stated that when plaintiff received the letter, they had known each other for 10 years, and they had just had their first child together. Mrs. Levy was not working at the time because she was a new mother, so plaintiff was the sole wage earner. She testified that plaintiff's receipt of letter coincided with a particularly difficult period in her life, since her daughter had severe colic and could not be relieved, so she didn't sleep at all for 3 months. Additionally, her mother was suffering from terminal cancer. So if plaintiff had to suddenly travel or was fined or imprisoned, it would have been detrimental and devastating to their family. According to Mrs. Levy, they could not afford childcare at the time, and plaintiff was the only one helping. So that means the dad is the sole provider, and they're struggling. They've been married. They've been together for 10 years. They just had their first kid. She's sick. She can't sleep. It's an emotional time for anyone. Then they get this letter from Joe saying, you gotta give me everything. You gotta be there on Boxing Day, the day after Christmas. You got a new baby, enjoying opening your Christmas presents. Well, you got to get your ass to New York and give me everything and bend over. Tell me what furniture you have. That's kind of like, and of course the plaintiff will make this sob story because he wants to get as much but enough empathy from whoever's reviewing this case as possible, right? But it kind of shows you what people actually go through when they get these like fraudulent debt collection notices that they just send out en masse, right? Now, I'm not sure if Joe actually did send them out en masse. That is what is alleged by the plaintiff. But no, it's stressful, right? $100,000 in damages over 10 years. One dad supporting the family. 10 years. Well, not 10 years. $100,000 over 7 years. Do you have $100,000 in your bank account? Nobody can afford a lawsuit, honestly, apart from maybe debt collectors. But who can say? She also explained that the plaintiff also provided emotional support to her mother and cared for the family dog. Oh my goodness, Joe! This is why it's Jova. This is when the judge is reading this. So this debt collector sent you a notice with no information, no background, no case, and you were caring for the dog at the same time as you got this letter. Guilty, $100,000 right then and there. So the dad's looking after the one kid and also the mother and the dog. Holy shit. Mrs. Levy claimed the plaintiff's behavior changed in December of 2016 after he received the letter. She testified that there was a quick switch in December where he stopped helping me with my daughter at night, and he wouldn't hold her anymore, and he wasn't even sleeping himself. Mrs. Levy elaborated that the plaintiff was just disconnected. He would leave the house around 4:30, 5 a.m., and he could no longer help me walk my dog. Oh my goodness. He didn't hold their daughter anymore. He didn't help me. He was short with the baby. He was short with the dog. Mrs. Levy also stated that the plaintiff received the letter. He didn't spend any time with her, terminally ill mother at all. The mother's dying of cancer during all of this. Now, is this guy like some saint? We don't know. This is what he alleges, right? This is what they've stated to the court. They could be making this all up. He could be a complete asshole. But this is what he's saying. This is what got him these damages. When counsel asked more directly how plaintiff's emotional state changed in response to the letter, she stated that he was afraid. He started working excessively and leaving the house a lot earlier. And he did not return to his normal emotional state until early in 2017. So they received the letter in like the end of 2016, right? So it got him disgruntled for a couple months, basically. On cross-examination, Mrs. Levy admitted that she knew plaintiff lived in New York in 2010, but didn't know if he'd lived there at the state of the address at issue or if he owed any money to the building's landlord. Okay, so that kind of clears up a little bit of the... this actually kind of clears up a little bit of the story. It seems like Joe was trying to collect on the behalf of an alleged landlord. So landlord dispute. Oh no, don't. Plaintiff testified after his wife. He explained that he had emigrated to the United States from Israel in 1990 and lived in New York until about 1990, for 20 years, 2 years. During that time, he struggled with alcohol and drug abuse. He was doing a lot of drinking and a lot of drugs. While living in New York, he acknowledged that he lived at the location for maybe a year, but did not remember owing any money to the landlord or having a judgment entered against him as a result. Plaintiff said that he received the letter in mid-December of 2016, and that it was a very terrifying moment and very scary. He explained that he thought if he did not comply with the letter's demands, he could face fines or imprisonment, or he was going to get arrested. Plaintiff said the letter also confused him because it required him to appear on December 26, which was Christmas time. It was Hanukkah too. Is it? When is actually Hanukkah? I don't know. When are the dates of Hanukkah? It's very strange, though. Like, that's the weirdest thing. Why would Joe issue this on December 26? Was he trying to, like, sneak in one last cheeky debt collection for the year to get that bonus? Who can say? Who can say? Did you say Jova or Jehovah? I said Jova. It's Jova. It's Jova. Plaintiff said he did not tell anyone, including his wife, about his feelings when he received the letter because there was enough pressure on the house already. He sent the letter. Said the letter caused him to lose sleep. He was very worried. Wasn't available as much as he was supposed to be when it came to caring for their newborn daughter. Plaintiff testified that the letter caused him to lose focus and that he had started contacting his addiction treatment sponsor daily, even though he previously only spoke to him 3 or 4 times a week. As to his schedule, plaintiff said that before receiving the letter, he would leave the house for work around 9 a.m., come home about 5:30. But with the added stress from the letter caused, he waked up early and began leaving the house between 6 to 7 a.m. and returning around 8 p.m. He also testified that he stopped exercising after receiving the letter. Plaintiff admitted that he began to feel a little better once he hired a lawyer 3 weeks later from receiving the letter. However, he testified that the stress did not totally abate until maybe 6 months later. When cross-examined, plaintiff clarified that when he hired counsel 2 or 3 weeks after receiving the letter, but he could not remember. In addition, he acknowledged that the complaint states that his attorney's first conversation with Nierman was on December 27th, 2016, 14 days after the letter was postmarked. And upon giving the letter to his attorney, he felt relief. Further, plaintiff admitted to while living in New York, he moved out of the location for 2 months for addiction treatment, which is why he could not remember if he had any debt related to his tenancy. He explained that when he returned to the building after treatment, all his furniture was gone and he was not allowed to enter. I'm starting to get a picture of what happened here. Finally, plaintiff acknowledged that he never sought medical treatment for his anxiety caused by the letter discussion. Hold on, I think the chat's broken. I'm going to reset this. So it seems like the plaintiff that Joe was suing, he came over from Israel, 1999, got plastered in New York, was kicked out of his apartment. The landlord tries to steals his furniture. Then he tries to claim, I guess, unpaid rent for 2 months or something. And then Joe comes in and is like, well, there's a judgment against you. You got to pay up, boy. You got to pay up. Just as he was having his first daughter, his mother-in-law was suffering from terminal cancer. And because of this, he stopped exercising and stopped walking the dog. Unbelievable. Unbelievable. Why isn't the chat not working? Restore chat. It's popped out. I don't know. It's not working. Chat's broken for me. Who can say? It's working on StreamYard. It's working on StreamYard, so I can read it through this window, but I can't read it from my main window, and I can't have it on screen. That's very annoying. Very, very annoying. We'll give it a second. Maybe if I refresh this, I don't know, give you guys a chance to like the stream. Hopefully this won't crash when I press refresh. We'll have to see. We'll have to see. No, it's just completely broken. Wonderful. Everything's broken. Oy vey. Oh my goodness. Am I getting DDoSed by the tribe? Is that what's going on? All right, reloading entirety. Excellent connection. There we go. There we go. Everything's working again. Disaster stream. Joe sued me. For what? All right, we'll get the chat back on stream. We'll turn this back to all chat instead of top chat. There we go. There we go. Everything's working. Shut it down. Yeah, I guess you could try. Legal standard. Do you want to read this? I think we don't need to read this necessarily. Actual damages. Oh, hold on a second. All right, the legal standard is pretty short. Even though court has already found defendants liable on some plaintiff's claims, plaintiff still bears the burden to establish his entitlement to damages. There must be an evidentiary basis for the damages sought, and the court must conduct an inquiry in order to ascertain the amount of damages with a reasonable certainty. But he did get damages in the end. He got $8,000 worth of damages. Actual damages. The standard of the Debt Collecting Act states that any debt collector who fails to comply with provision of this subchapter with respect to a person is liable to such person in the amount equal to the sum of any actual damages sustained by such person as a result of such failure. Well, that kind of makes sense, though, because I think he was trying to get the guy to pay up $9,000. So it kind of makes sense that he got $8,000 in damages. Actual damages are intended to compensate the plaintiff out-of-pocket expenses, personal humiliation, embarrassment, mental anguish, and emotional distress. Plaintiff argues that he's entitled to recover the $3,000 spent on his hiring counsel to represent himself in defending against the letter prior to the commencement of his action, as well as $30,000 to $50,000 in emotional damage in support of his damage claims. Plaintiff points to his retention agreement with the, that's the law firm, also known as Schlegel Law Group, which states that he was required to pay a flat fee of $3,000 for representation. That's a really good return. You pay $3,000 and then the judgment against the opponent is $100,000. Holy shit. Now, obviously, this went on for years. So he paid more than that. But a flat fee of $3,000 for representation in connection with the alleged judgment against him. Testimony that the letter had a negative impact on his sleep, daily routine, and general well-being. Testimony that the potential penalties described in the letter made him worry for his newborn daughter and wife because he provided for them. Testimony that the letter triggered additional urges to relapse and consume alcohol, which required more frequent contact with his sponsor. So he's an AA. And wife's testimony corroborating his emotional damage and the effect on his family. In response, defendant contend that plaintiff was not entitled to emotional damages because there is simply no objective evidence of anxiety or emotional distress related. It's all made up, you crazy psycho. What are you talking about? Defendant posit that the real reason the plaintiff's distress was the letter prompted him to remember that he was in debt for failing to make payments while living at the address, which he did not remember since the time the debt was incurred. He was hospitalized for substance abuse treatment. Defendant offered no argument into opposition to the $3,000 fee plaintiff offered to retain counsel. Initial engagement fee. Plaintiff is entitled to reimbursement of $3,000 he paid for the law group to represent him against the alleged defendant. Plaintiff submitted his retention agreement to the law group, which shows he was required to pay $3,000. Let's skip through some of this. He got $1,000 in actual damages because he made 3 to 4 payments in response to the thing. Emotional distress damages. Let's take a look at this. Similarly, plaintiff is entitled to an award of emotional damages, not in the amount requested. So he doesn't get his $30,000 to $50,000 that he wanted from Joe Boy. Prevailing plaintiff in a federal, what is it? The Fair Debt Collection Agency Act. Suit may also recover actual damages for emotional distress. Plaintiff requires actual damages, bears the burden of proof. Although plaintiff may rely on his or her testimony to establish actual damages, he or she may explain the circumstances of injury in personal detail. He or he and may not rely on consolatory statements. Okay, gonna skip through some of this. I'll see if there's any really salient points. Okay, we'll go down to what was actually awarded. So he asked for $30,000 to $50,000. Instead, an award of $5,000 in emotional damages is commensurate with the evidence presented in this case and is in line with similar cases in this circuit. Awarding of $1,500 in emotional damages where defendant made numerous calls to the plaintiff and their family members without sufficient justification for doing so. So Joe's ringing this guy up in the middle of the night. I'm going to make you pay, boy. I'm going to make you pay. I'm going to take your little dog with you. Without sufficient justification for doing so, the plaintiff complained of loss of sleep and anxiety. Let me see what else is in here. There's a bunch of more case law. Attorney's fees. I'm kind of curious about this. Plaintiff argues that the court should award counsel $187,000 in attorney fees for 517 hours because this was a contested action that required extensive motion practice and an inquest hearing. In response, defendants contend that this award should be reduced by 63% because the number of hours billed was excessive. I mean, this is over 7 years. 500 hours doesn't seem that ridiculous. And much of the time expended for was filing a motion for default judgment that was ultimately denied, pursuing claims that were dismissed on summary judgment, docket number 119. Let me see. The Fair Debt Collection Agency Act authorizes the prevailing party to obtain an award for the cost of action together with reasonable attorney's fees. The starting point in determining attorney's fees awarded is a calculation on the lodestar by multiplying the reasonable hourly rate by the number of hours reasonably expended on litigation. And that's just how they calculate how much they pay lodestar. Let's see. Evaluating the attorneys must be based on the hourly rate, the rate we're going to pay. Yep. Okay. In addition, the party seeking attorney fees bears the burden of demonstrating that the claim numbers of hours is reasonable. Yeah, kind of seems pretty standard stuff here. Let's see, so he hired. In an initial matter, the court finds that the requested hourly rates are reasonable under the circumstance. Plaintiff seeks to recover fees for 9 different timekeepers, including 2 partners charging $450 an hour, 1 counsel charging $325 an hour, 2 senior associates charging $325 per hour, 1 junior associate charging $200 per hour, 1 law graduate charging $150 an hour. Law graduates get to charge $150 per hour? Jesus. And 2 paralegals charging $100 per hour. Look, paralegals get paid $100 an hour? What the fuck? Those paralegals should be mining the salts mines for not getting their law degrees. Suffer, paralegals. No, I only know 1 paralegal, and she's quite nice. The rates are largely in line with the prevailing market rates, so it's all in good standing. There we go. Good stuff. Let's see. However, the time expended, the number of timekeepers assigned to this case, is excessive under the circumstances. Plaintiff seeks to recover 517 hours. That's almost as much time as I've spent playing Faster Than Light. I do play that game quite a bit. Spent on the case by 6 different attorneys. While this case included motion practices as well as a hearing on damages, the average subject matter is not complicated, and the hours purportedly expended far exceed the hours awarded. Awarding 100 billable hours in a matter should be for the claim. In fact, the court was not able to find, nor does the plaintiff identify, any recent cases in this district court where they awarded over 400 hours of time. Moreover, much of the motion practice in this case involved plaintiffs pursuant to the New York GBL claim. Interesting. Your mom's a paralegal? That's who I was talking about. You got him.
You can't keep getting away with it.
Oh dear. No. Just having a bit of a giggle. The court is mindful of the time plaintiff was forced to expend on opposing defendant's belated motion to dismiss on standing grounds, but seeking an additional $48,000 for 100 hours of his attorney's time on a single brief on a single issue is disproportionate to the needs of the case. Okay. All right. I think that's the costs. Plaintiff argues that he should be awarded $5,000 for the costs incurred in this case. How does this get to $100,000 though? Conclusion. All right. For the foregoing reasons, I respectfully recommend that plaintiff be awarded $8,000 in actual damages, $500 in statutory damages, and $103,000 in attorney fees, and $6,000 in costs, basically, for a total of $117,000 notice. So it's on notice. There you go. There's Judge McCarthy going through the emotional damage report. There we go. There we go. Now there is one other thing before we reach the end of the Joe segment. Like, oh, let me know what you think in chat. If you think Joe's a good boy, he made a mistake, but everyone makes mistakes, put a 1 in the chat. If you think Joe was just trying to get as much money out of this guy on the day after Christmas, and he does it all, he's just a debt collecting asshole coming for your kids on Christmas. It's the Grinch logic. Put a 2 in the chat. 2 for bad Joe, 1 for good Joe. We did a poll at the beginning of this, and with 800 votes, holy shit, 800 votes, we said 16% it was a mistake. 25% say he's a debt collecting fraudster. 47% said oof, $117,000, and 12% just liked the stream. I much appreciate those people that like the stream. It looks like there's a lot of. It doesn't look so good for greedy Joe Grinch logic. So, if you want to see this case for yourself, it is on Court Listener, Levy v. Law Offices of J. Henry Nierman, District Court of New York, and the last was updated October 2nd, but the last filing was September 24th, so this is pretty recent. I don't think there's been any public statement. I very much don't think there will be. Joe has talked about his debt collecting days in the past, and it seems like he's not having a good time. It's kind of interesting, though, because a lot of people criticize the Rekieta man, the Rekieta meme, the tablets right now. A lot of people criticize Nick, saying that like he's going to get absolutely disbarred based on his actions, but lawyers commit crimes all the time, and it's not really a big deal for disbarment, right? Like if you lawyers doing coke isn't a big fucking deal. Very unlikely to get this. This is the first thing in LawTube that I think would actually potentially warrant disbarment, sending out fraudulent debt collection things. It seems like what happened is that Joe, from me reading this, almost no one said Nick was going to get disbarred. No, actually, many people think that he's going to get disbarred. A lot of people did. Maybe not my chat, because my chat's more smart than I am. But anyway, it seems like Joe knew this guy, knew this landlord. So so basically, to sum up the story, what happened here is an Israeli immigrant comes over to America. He lives in New York for 20 years. He stays at one apartment for 2 months. During the 2 months he's staying at the apartment, he gets high and gets sent to rehab, basically, or he gets taken into, he's completely coked out, and he gets taken away. He comes back, his apartment's locked, all his furniture's gone, and he just like get the fuck out of here, just get the fuck out. So he leaves, and then that was in 2010. He then receives a letter 6 years later from Joe saying, look, there was a court settlement against you. I don't have the case number, and I can't show you this court judgment against you, but you were judged that you owe $8,000 for 2 months rent. And I assume damages of the apartment is probably what was in there. I don't know. How much does a New York apartment cost? I know $4,000 a month probably sounds pretty reasonable. This is 2010 though. So I guess it's like 2 months of rent is what he's trying to sue for. But there's no court case. I can't find it. And it seems like Joe didn't post the thing. So did Joe either send this out because maybe he just buys a bunch of like old debt that hasn't been claimed? There's a lot of debt collectors do that. They just buy debt from people for like, a fraction of the actual cost. And they send out as many debt collection notices as possible and hope that a fraction comes back, and that's how they make their money. So is that what Joe did? Or did Joe know this guy? And did he make up this story to try and intimidate this guy into paying this $8,000 worth of debt that he alleges that he has? Now, the defendant, not the defendant, Joe's the defendant. The plaintiff says that he can't remember any of this because he was coked out of his mind. Many such cases. You hate to see it. This goes on for 7 years. Joe tries to get it dismissed. He says, well, actually, sorry, there's a part I missed there. So he sends out the letter to arrive in New York. The guy now lives in Florida. 6 years later, he's living in Florida. Joe sends in the request for everything. He wants him to bend over and show me everything. And no less, he has to do it in 10 days. And it has to be on, I think it's 10 business days, not like, it's like 13 actual days, whatever. But it's a court holiday, and it's everybody's holiday. It's Boxing Day, the day after Christmas, 10 a.m. after Christmas Day. And then the guy says on December 22nd, December 27th, so the next day after Boxing Day, so he still takes his holiday, good for him. He says, he's like, rings up Joe and he's like, look, bro, can you show me where I got this judgment against me? And Joe says, yeah, I'll send it to you next week. He just then ghosts the guy. He doesn't send him any other information. He doesn't give him anything. Joe then goes on to call this guy at odd hours of the night and day, trying to get his money. He's like, I'm going to get my money, man. But he never supplies the court judgment. It seems completely fraudulent, honestly. And this goes on. And then he tries to get dismissed. He doesn't really say anything. I can't find Joe's defense on this. I've been looking for quite a while, but I couldn't find anything that Joe has said about this in either the court documents or on socials or anything like that, or anywhere. So Joe has no defense in the public sphere. But it goes on for 8 years. And then Joe's racked up this dude 7 years of emotional damage and 7 years of lawyers' fees. The judge is like, no more appeals, Joe. It's over. You got to pay. And then the judgment comes down $100,000, close to $120,000. That's what it seems like in my point of view. Now, I could be wrong. If Joe has a very good, if Joe's probably going to come out and say, if he does come out and say this, I assume what he would say is that this guy was a drug addict who destroyed an apartment and he wouldn't pay their landlord. Based landlords, we love our landlords. Landlords are the best people ever. I don't know. Maybe that's what he'll say. But as a sort of funny aside, what has Joe been doing recently? Now, this is when we get into the fun makeup stuff. There is no factual basis for what I'm about to say, but Joe is currently doing a fundraiser for $50,000. Bit weird. Campaign created by Joe Nierman. Campaign funds will be received by Joe Nierman. That's interesting. For the ungagged Trump, fight for the First Amendment. See, I kind of preluded to this at the beginning of the stream. But Joe, and honestly, Trump does deserve to be ungagged on this. This does seem unconstitutional. But alleging the allegations of this give, send, go is that Joe is submitting documents and he's trying to get Trump his First Amendment rights back. He's trying to. The case is pending in the New York Appellate Division of the First Department. The petition fixates on how Judge Merkin misanalyzed the very Supreme Court case that he cites and concluded. So Joe's trying to defend Trump, but he's apparently billing himself. And he's raised $27,000 so far. So some people, not me, have suggested that this is a bit of a scam. Now, I do think that Trump should be ungagged on this one. But it is interesting. When was this created? I want to see, when was the first date of this? Can we find out when this was created? Again, this is just complete. I'm not going to bat on saying that this is what's happening, but it's a bit funny in it. I want to see. I don't know. I'd have to go through all the donations, I suppose, to get to the very first one. So look, this has been going. Okay, never mind. So I found out what to find. This has been going on for months. So this came out before the judgment against Joe. So he started this multiple months ago. The judgment came out against him in September. But it is interesting. It is interesting that this money is created by Joe Nierman and the funds will be sent to Joe Nierman. Bit interesting. Oh, dear. It's Jova. I think it might be Jova, boys. But the stream's not quite Jova yet because there's one more thing. We got to check in with. We've got to check in with Viva and Barnes. Viva, Barnes. Oh, wait, I forgot. Hold on a second. Let me see. What is this? Here it is. Sorry. Okay, there we go. We've got to check in with Viva and Boss Baby. There we go. Viva and Boss Baby. You've been dying to see what Viva and Boss Baby have been talking about. I was calling them what was I calling them? Jabba the Hutt and Salacious Crumb over here. But I think this is funnier. This is much, much funnier. But you may remember that the last time we saw a Barnes clip, Barnes was talking about how Sean should go back to analyzing anime, Legal Mindsets doing some weird shit over in Thailand, and that Rekieta is a shoo-in. He's already won the case. This is crazy. So now we've got a bit of an update from the Barnes team. This is called from Alyssa Clips. Viva and Barnes, update on the Rekieta case. Frank's motion denied. So they said that it was going to be a shoo-in. No, they said it was 100% slam dunk case that Rekieta was already a free man. But I know you want to get back to your families, so I'll play this at 1.25 speed. It's only 7 minutes. But with a 5-pounder from I says, the funds are being used to pay for Good Joe for his honest and hard work. Don't you dare suggest otherwise. Okay. Joe's a good, honest debt collector. He didn't do nothing.
Any updates on the Rekieta case?
All right, let's
so I believe there were some updates on the Rekieta case last week. I was trying to follow along, but from what I understand, Rekieta, Nick, or his lawyer, had presented a bunch of motions to dismiss all the charges and strike the evidence as inadmissible. And I don't think it comes as a surprise. So I don't think it's as devastating as anybody thought it would be. But the motions to dismiss were not granted; they were dismissed, and the motion to exclude the evidence for the time being was not granted. Is that about the size of it?
Well, there was a request for a Franks hearing. So a Franks hearing, if you get a Franks hearing, it usually means the case is going to be dismissed right out of the gate.
But he didn't get the Franks hearing. Bit unfortunate. It's interesting to note is the demeanor of Barnes is that if you watch the previous clip, and maybe I'll bring them up to compare. Barnes is like, this is crazy. Rekieta's just going to win. All these crazy law tubers don't know what they're talking about. Like, Barnes is the only one, essentially, who's been on Nick's side. And he was the only one that was wrong. Interesting.
But they're tough to get with a lot of judges. That doesn't mean the judge's decision is correct. There are some people out there that constantly confuse power with principle. So the fact that judge says something tells you nothing about the law. It tells you what people in power do, but it doesn't tell you anything about principle. So some of these...
What? The argument was about the legal merits of the case. It wasn't about the morality. Like, I kind of agree at some point on the morality that I don't think that drugs should be criminalized the way that they are. But this is just cope. This is just cope and Sneed. That's what it is. Barnes not looking so good over here.
Same people that celebrate the exercise of power in this case, I think wrongly denying a Franks hearing, they are the same people who would condemn such power when it's been utilized against Trump, for example. Do you think the New York was Judge Engoron right? It's according to the logic of some of these people, if the judge says it, that must be the law. It's some of the most simplistic notions of the law I've ever heard or read. Now, sometimes it just reflects personal or political prejudice on the topic or subject matter involved, and that can cross all kinds of barriers. And there's people that are obsessed with hating on Rekieta. So it's amazing. You see these people that pretend to celebrate civil liberties and civil rights, celebrate the abuse of those civil rights and civil liberties when they don't like the target.
Well, let me play a little devil's advocate, because some people might say, well, when the judge comes down with a good decision, it's the right decision. When they come down with the wrong.
V was trying to make his way out. He's trying to sneak his way out of this. He's not married to the position that Barnes is talking about. I think the thing is that Barnes always like to play. I'll play devil's advocate myself. Barnes never talks about what the reality of the law is. He talks about what the law he thinks it should be, which makes his legal opinions worthless. Because we can all argue about what the law should be. Oh yeah, it'd be great. It'd be great if this happened. It'd be great if that. That's not what people hire lawyers for. Lawyers aren't hired to talk about how good the world could be. They're hired to get you out of legal problems. And none of Barnes's defenses seem to be useful for doing that, which means that his lawyer ability is useless.
Wrong decision, they lack principle. In this particular...
Because or I disagree with him in the interpretation of the principle.
Well, in this particular case...
You should always separate principle from power. One is, what do you think tactically is going to happen? As opposed to, what do you think legally should happen? And those two should not be conflated in doing legal analysis. And there's a tendency in the legal academy to conflate them. Because what it will do is reduce, it makes objective truth subject to subjective power. And when you do that, you no longer have objective truth. You no longer have an objective principle. The law is supposed to be...
I think there's at least one man in this conversation who is losing touch with the objective truth.
The idea of it is that there's an objective truth that we're seeking to discover as advocates, as jurists, as jurors, etc. Not that it's subjective, that it's subject to subjective whim or interpretation. So so I always say, when the judge disagrees with me, I disagree with the judge. I just don't say, oh, I must have been wrong on the principle because somebody in power disagrees with me. That's and whether they agree or disagree, that's the other aspect to step back from. So when you're analyzing these things, look at what is the objective truth of the matter and always separate that, because they want the powers that be want us to divorce ourselves from the meaning, from the objective truth seeking at all, and say, you need to defer to subjective power. And whatever we say is the law. Whatever we say is the rules. We don't need...
I think what he wants to say is you need to defer to his opinion. I think that's what he really wants. I think he just wants everyone to agree with him, but not looking so good over there in the barn.
No stinking badges. I find that idea dangerous to any sense of constitutional liberty or governance. It's part of the sort of left in general, but it's also part of the power in general. No objective truth. Everything's subjective. So all of a sudden, nothing is true and nothing is real. And you get into all those philosophical
what is he talking
aspects
about?
that have been popular within parts of the academy for 60 years. And some of these people that are so deferential to power constantly do that. When a judge issues a ruling, sit down and say whether you agree with it or disagree with it and why. As opposed to, oh, the judge agreed with this, so that must mean the principle was right. I was either right or wrong on the principle, regardless of.
I don't think anyone's really argued that just because a judge said this, it means it's the right and moral thing to do. I don't think anyone ever makes that argument, except for maybe some absolute. Well, I shouldn't use the word I was going to use, but some very, very shit. Everything I was going to say is potentially very, very mean, so I probably shouldn't say that. Let's just continue, shall we? Before I get myself in more trouble.
The question is this: I view these types of motions, especially like a motion to dismiss and a motion to exclude evidence. The vast majority of the time, they're not going to be granted by the judge.
Not at a trial court, not in America, unfortunately.
It's all American. Didn't he? Wasn't Barnes like saying like, oh, "This is a shoo-in. Rekieta's already free. He's practically free already. He's practically free." Yeah, I'm not so sure about that. Don't feel so good. Don't feel so good, Barnes Bros. I humbly ask you to play the Coping and Seething song. I don't think I have a link for it still. Is that the AI one you're talking about? I think I remember it, but I don't have it on my Rolodex. So,
talking about the tactics. One, you always raise them because you raise every defense. Two, tactically, you want to make it as robust as possible to preserve issues for trial and to preserve issues for appeal. That's where that's where a lot of the plea bargains that are done in these cases are done in two different ways. Either the government fears losing power broader than just the individual case on appeal, and so they come to a more reasonable terms. If they had lost with the trial court, the case was dead. If the trial court even orders a Franks hearing, and you have a cop subject to cross-examination on his entire history of a range of, they dismiss right away typically, or they just dump the case. Franks hearings are supposed to be commonplace, but they're very rarely granted. So everybody knows that. That's part of the system. You're not likely to win out of the gate with any of these kind of motions tactically. I disagree with.
So these are all Hail Marys. Nick says, "Oh, it's not a Hail Mary. Of course not. No, it's a very, very real, very serious legal strategy. No, these are all pot shots." And like, I don't begrudge him for trying. Like, of course you should try. Like, if I was arrested for anything, I'd be doing if there's any dirty trick to get out of like this sort of thing, I'd try it too. I can't blame him for that. But like, the thing is that he said that this was a good idea. He said that it was a smart idea, and he said that it was basically a shoo-in. Well, unfortunately, they were wrong again.
That as a matter of principle, because our courts are way too deferential to power. And they don't meaningfully enforce, in criminal defense cases especially, our civil rights. That's why I talked about the 8th Amendment and P. Diddy and Ghislaine Maxwell and Jeffrey Epstein and Sam Bankman-Fried. These political cases where they know the person's disliked, and most criminally accused are going to be publicly disliked, they know they get away with eviscerating our constitutional rights and liberties. And these people that celebrate that because they don't like the individual, whether that's Nick Rekieta or whether that's Sam Bankman-Fried, doesn't matter who it is, that's it. That's how you lose your constitutional rights and liberties. Another way you lose it is by confusing objective truth with subjective power, with principle with power. Don't make that confusion. You may be right or wrong in your interpretation of the principle.
What principles does Barnes have exactly? Calling everyone he doesn't agree with, like anime weirdos, or alleged. He insinuated that people that didn't agree with him were going to Asia to find children to pay for sex. That's his principle. Everyone that doesn't like me is a pedophile. What was Barnes's catchphrase? Confession by projection. Something to think about. Sean should just go back to analyzing anime. I actually don't think Sean likes anime at all. That was a fun one. Bit of a weird one. Nate and Kurt, they don't know what they're talking about. Seems like everyone was right except for Barnes. Funny how that works.
But never defer to power to who is right as to what the truth is as to a principle. Because that's how power gets away with a lot of bad stuff.
I heard the news. Some people might want to frame it as a massive defeat for Rekieta. I presume that these motions were never going to get granted in the first place. So it's they're going to take
long shots. I mean, you take the long shot up front, and then you just keep taking the shots. But it clearly established a robust basis because the government had to take time to issue a different reply. They didn't want to do a straight oral argument.
No, they had to take time because there's 4 hours of fucking live stream to go through.
Out of the gate, they conceded on a range of issues and topics. So if you're in the government, you know you've got a long fight. The smart thing for them to do, given the low significance, frankly, of this case,
Benjamin Lewis says, meme, you just don't understand the laws. True, but neither does Barnes. So I think I'm doing okay. I think I'm doing okay there. Barnes, sorry, not Barnes. £5 from I says, Barnes, Nick, like Diddy, and Sam Bankman-Fried. Finally, some truth from this man. Oof, that's not good. Nick not looking so hot out there.
I mean, I know some people climb the walls because they get really upset over people allegedly using certain unapproved drugs. I find more objectionable people that kill people with legally authorized drugs.
That's a weird way to. Wait, say that again. Say again, Barnes.
I find more objectionable using case. I mean, I know some people climb the walls because they get really upset over people allegedly using certain unapproved drugs. I find more objectionable people that kill people with legally authorized drugs.
What is the argument here? Well, Nick may have done some drugs, but have you considered the death penalty? Wait, what? Look, the only death penalty is going to be if Nick tries to defend himself in this case. That's a death penalty right there. Even though that's not even, you can't even be penalized to that, like on drugs. It'd be just funny. It's like, just watch one of my streams. Death penalty. Holy shit! What a moment of zen from Viva and Barnes, or Viva and Boss Baby, as we like to say it. Whoa. What a fun first October. It is Joshtober, of course. Probably do a stream tomorrow that nobody will watch because I'll be talking about Rings of Power, because it's the finale. The final episode of Rings of Power comes out tomorrow. I'm going to be in the editing mines for about 20 hours over the next 2 days. It's not going to be fun for me, but I might do a stream tomorrow talking about what I think is shit about Rings of Power, which is everything. If you have not checked out my channel, I do have episode 7 of the Rings of Power video. I'm not even logged into my own channel. What the fuck is it? Why? It's a fun one. It's my other content. I know like there's a strange combination to cover the balldoverse collapse and also TV. It's an odd combination, but you check out Rings of Power episode 7 review, The Siege of Eregion. It's pretty funny. People are saying that they like it. There's a lot of fun little pews in it. I'll give you a brief look at the big battles, the big boy battles that they have. Let me see. Should be one about here. Here you go. Here's your moment of zen. Look this.
Wow.
Another moment of zen. I'm double dipping on these.
Really.
And Celebrimbor's dead. But he got better.
Really
He got better. Also, elves can't hear anything. Dwarves are killing families. Wait, this is the good part. The orcs bear their feelings, and they talk about how. Oh no, I'll show you. I'll show you when Elrond. I'll show you when Elrond commits a war crime. How about that? That's a good part of this video. All right, here we go. I'll show you this part. Elrond committing a war crime. This is pretty good because his horse gets killed. Orcs fighting it all. There you go.
That's my horse!
Which means that this orc has to die. Good job, Wait, what? No, Elrond, don't. That trebuchet is pointing straight to Eregion. Elrond, no, there are innocent elves in that city. No, Elrond!
You're fired.
Elrond, why are you doing it? Think of the children! And Elrond then killed a bunch of elven children. It's very disappointing. Very sad. Amazon Rings of Power. Reviews coming up very soon. Well, that's it. The stream's over. You don't have to go home, but you can't stay here. Probably back tomorrow with probably Rings of Power. I know most people in the chat don't care about that, and they won't come and watch it. But if you do, it's there for you. Then we've probably got a Friday stream coming up, and then I'm not sure what's happening next week. We'll have to see. Big Nick updates will happen at the end of November. November 26th, the day before Thanksgiving, is his he has to submit he's either guilty or not guilty, and that's where things get really spicy. And who can say? Maybe if we'll see how Joe, if there's any updates from Joe. I assume he's probably not going to talk about this. Honestly, that's the smartest strategy. Just don't talk about any of the mistakes you make, unlike me, who talks about them constantly. But with that said and done, peace, chat. See ya. Have a good one. And sorry, Kiwi Bros.
Sorry, Kiwi fags. Life doesn't work out the way you pretend it does.